children. It is one of the few programs in North Carolina with expertise in special education and school discipline law. In addition to fighting for rights of children, the clinic also takes on other matters related to their general well-being. Before joining the faculty here at the law school, she practiced poverty law for 13 years as a legal aid attorney in Raleigh and Winston-Salem, specializing in the law of government benefits. She is the author of The Advocate's Guide to Assistance Programs in North Carolina, a complete reference for the professional to help the poor, the elderly, and the disabled get the benefits they need, and co-author of A Consumer's Guide to Health Insurance and Health Programs in North Carolina, among several other notable publications pertaining to gender equality in the legal profession, health law, and government benefits. In 2010, the North Carolina Justice Center honored Professor Wettach with the Defender of Justice Award. The award recognized both Professor Wettach's lifetime of work as an advocate on behalf of children and families in the state. She was also recognized for her advocacy as a lead attorney in a case before the North Carolina Supreme Court, challenging the lack of education options for students subject to long-term suspensions. She is a recognized champion of and expert in children's rights and equitable poverty law policy. It is thus with great pleasure that we welcome to kick off the 2011 Duke Forum for Law and Social Change Symposium, Our Youth at a Crossroads, Professor Jane Wettach.
Well, good morning, everyone, and welcome to the Duke Forum on Law and Social Change Symposium on the Collateral Consequences of Juvenile Adjudications. I don't think I've ever been to a conference that had a title with so many syllables. But to our guests from places far beyond Duke, as well as to Duke students and faculty here, thanks for coming to participate. I want to congratulate the students on choosing such a timely topic and working so hard to put this symposium together. And I feel confident we're all going to be enriched today and inspired to continue to pay attention to the issue of collateral consequences of juvenile adjudications and work for change in that area. As Aubrey mentioned, here at Duke Law School, we have a children's law clinic that represents children, and often in cases related to their education. A number of years ago, in my role as the director, I got a call one day from a public defender down in Scotland County, and he had been representing a 14-year-old boy on a juvenile charge. The boy had been accused of sexual contact with his 4-year-old stepbrother, and for a variety of reasons, it had taken a year from the time of the event to the adjudication. The adjudication had just occurred. During that year, the boy had been in public school completely without incident. He had not gotten in trouble, hadn't had any problems with any of the children in his classes. But he was now adjudicated a delinquent, and according to law, his juvenile court counselor did what he was required to do, which was call the boy's principal. And as soon as the principal got this call, he called the boy into his office and said, "I'm sorry, you can't come to school anymore." So just like that, that was, at least at the time, we thought, the end of his education. So that was one of the first clinic cases involving the collateral consequences of a juvenile adjudication. I didn't actually know the term at the time, but I certainly knew immediately the impact of that consequence on his life. So technically, collateral consequences are these various penalties and disqualifications that individuals face by operation of law, incidental to a criminal conviction or a juvenile adjudication. So for adults, these can include restrictions on voting, prohibitions from running for office, deportation for immigrants, exclusions from certain types of employments, restrictions on where someone can live and on what kind of property they can own. For juveniles, they can include exclusion from school, disqualification from driving, long-standing losses of personal freedoms, eviction from public housing, enhancement of future sentences. But less technically, more informally, collateral consequences are really all the various aspects of the impacts on children that result from their interaction with the juvenile justice system, including impacts on their family relationships, their education, their future employment prospects, and their mental health. Understanding the collateral consequences is especially important given our society's heavy reliance on the juvenile court system to manage children's behavior. All of us have heard the kinds of stories of adolescents that are now referred to juvenile court, increasingly by school officials who either choose to or who are forced to refer cases to court. Here in North Carolina, the North Carolina State School Board recently, just in 2010, passed a policy that requires all principals to report every criminal offense that occurs on school property to law enforcement. Because a principal was actually prosecuted for failing to report an event that occurred at her school, principals are reading this law in an extremely literal and narrow way and vastly increasing the number of referrals that are getting to law enforcement. I recently read an article in the paper about a principal who referred to court a child who had taken a plastic pen, taken out the ink cartridge, making it a hollow little casing, fashioning a few little plastic pellets and shooting them off at his friends in the cafeteria. He was charged with assault, and off he went to the juvenile system. So as we're exploring today, the impulse to criminalize normal adolescent behavior is having consequences far beyond what the principal may be thinking about or know about when that referral to law enforcement is made. So the phenomenon of harsh collateral consequences is in many ways, in my view, just one of many examples of our society's somewhat schizophrenic and contradictory approach to children. Our rhetoric recognizes the need for all children to have strong family support, but we resist providing external scaffolding to families who are challenged in providing what their children need to have safe and healthy lives. We say we understand the importance of a child's early development, but we fund our prisons much more richly than we fund our preschools. We acknowledge the value of a high education for all children, a high-quality education for all children, especially those who come from disadvantaged backgrounds, yet we persist in funding our schools based on the wealth or poverty of the community in which the student resides. We say we recognize that an adolescent's abilities to exercise judgment, control impulses, and foresee consequences are not yet fully developed, but we often hold our young people to adult standards, and we punish them harshly for not meeting those adult standards. And we say that the juvenile justice system is about rehabilitation and second chances, but we impose these harsh collateral consequences on juveniles that impede them from moving past their mistakes and onto more safe and productive lives. As the existence and impact of collateral consequences has grown, so has the attention paid to them. Lawyers, judges, policy analysts, advocates, and scholars alike have begun to grapple with the extent to which collateral consequences of juvenile adjudications are overshadowing the adjudication itself. As the consequences are more severe, questions have arisen about the need for juveniles to know about the consequences at the time of their adjudication. Commentators have addressed whether the lack of knowledge about collateral consequences should affect the validity of a plea agreement, or whether an attorney's failure to educate a juvenile about consequences might support a claim for ineffective assistance of counsel. Others have focused on the reverberations of collateral consequences on the life of a juvenile when he is transferred to adult court and treated as an adult defendant. There is some good news on the horizon. As collateral consequences have been studied, some initiatives are taking place to try to blunt some of the harm. For starters, in many jurisdictions, there's starting to be an effort at least to collect information about the collateral consequences so that they are known. The American Bar Association has an ongoing project to collect information about the collateral consequences of juvenile adjudications in all 50 states. Likewise, the National Conference of Commissioners on Uniform State Laws has drafted the Collateral Consequences of Conviction Act, which was approved in July of 2009. Although not yet law in any state, this model act requires every state to collect the information on the collateral consequences into one document and requires that defendants be notified of the collateral consequences at the pretrial stage, at sentencing, as well as prior to release from incarceration. The act specifically includes juvenile adjudications, so if any of the states were to accept, make that part of their state law, we'd go a long way, at least towards defendants knowing what the collateral consequences are. Throughout the country, we're seeing more continuing legal education for lawyers representing juveniles to educate them on collateral consequences so that they can help their clients understand them. And in 2010, the United States Supreme Court acknowledged the importance of collateral consequences when it found in the case of Padilla versus Kentucky that a defendant was denied the effective assistance of counsel when his lawyer failed to inform him that his guilty plea would subject him to deportation. So today we have a rich lineup of speakers to add to the scholarship and conversation about the collateral consequences of juvenile adjudications. We've got the first panel here, which will provide us with an expanded understanding of the collateral consequences of juvenile adjudication. Lisa Thoreau, Chris Gowan, Megan Wood will detail how the collateral consequences often swallow the crime and sabotage the promise of a second chance that is supposed to characterize the juvenile justice system. Their work explores the destabilizing effects on poor youth of the consequences of juvenile adjudication. They'll urge an empirical approach to answering some of the questions that must be answered so that reformed policy is based on data and not just political ideology. They'll also share the details of the American Bar Association's work in this area. Also on the first panel, Rhea Shaw, Lisa Campbell will shed light on the importance of the role of defense counsel in helping juveniles grasp the impact of collateral consequences. They'll comment on the case of Padilla versus Kentucky and urge that the same approach be applied in juvenile cases, which would encourage juvenile defenders to take the initiative to disclose collateral consequences to their clients. They'll also share their insights on how to overcome some of the practical obstacles in communicating with juveniles about collateral consequences in a way that's effective in conveying the relationship of the current adjudication to the potentially devastating impacts that occur long after the day in court. Aaron Kupchak will share work that he has done with Jeff Fagan on the incarceration of juveniles. They've done a lot of interesting original work interviewing juveniles imprisoned in both juvenile facilities and adult prisons. They'll present their research, which portrays the pains of imprisonment for juveniles, compare the relative consequences of juvenile facilities and adult facilities. Their work, it seems to me, reflects yet another one of our strong contradictions in our society's approach to juveniles. Even when the research shows that incarcerating juveniles does more harm than good, we just keep doing it. The second panel today will put a spotlight on the connection between education and the juvenile delinquency system. Kate Burdick and Jessica Fearman will share the facts about the profound educational needs of juveniles in the delinquency system. Their research shows that the children in the juvenile system are 4 to 6 times as likely to have educational disabilities that are interfering with educational success. These unrecognized or unremediated disabilities often are intricately intertwined with the behaviors that have landed these children in the juvenile justice system. These speakers will identify how a federal funding stream through Title I of the Elementary and Secondary Education Act can be used to pay for assessments and screens that can create a nexus between the juveniles' educational needs and legal entitlements that will help them link youth to appropriate educational services. Specifically, they examine how such screens can assist in providing children with appropriate special education services, disability accommodations, remedial education, credit recovery, and higher education preparation and school stability. Also on the second panel, Dean Rivkin focuses on truancy from school. He will share his research showing the connection between truancy prosecutions and collateral consequences. This is of particular importance given the statistics. Nationally, between 1995 and 2007, the number of petitions in juvenile court for truancy went up by 67%. Professor Rivkin will advocate for the decriminalization of truancy as a way not only to protect students from harsh collateral consequences, but as a way to force our other support systems, schools, mental health services, social services, to confront the issues that are keeping juveniles from voluntarily seeking an education and going to school. In the third panel, we're going to hear about some particularly difficult collateral consequences and their counterproductive impacts on children. David Rossman and Wendy Kaplan have looked at the effects of public housing law that subjects families to eviction when one of the members of the family has committed a criminal act or a juvenile act. They explore the assaults on both the stabilities of families and the rehabilitation efforts of juveniles that result from these evictions. They'll also present recommendations for striking a better balance between the public safety concerns of public housing authorities and the juvenile court's goal of rehabilitation. Finally, on the third panel will be Elizabeth Frankel. Her work shows how the immigration consequences of juvenile adjudications can undermine the stated purpose of the juvenile justice system. Although a juvenile adjudication does not have the same automatic deportation impact as an adult's criminal conviction does, a juvenile adjudication can result in detention and can sometimes lead to deportation, often without any adult supervision, and to a country where the child has never lived or has anyone to care for the child. Ms. Frankel will share her recommendation that a best interest of the child calculation should be made by court officials before a child is deported. So we'll move from the academic to the real world at lunchtime, and our keynote speaker is Judge Marsha Morey. Judge Morey's our Chief District Court Judge here in Durham, and she's been a judge for nearly 12 years. She is an outspoken and passionate advocate for juveniles. She's been very vocal statewide as a critic of our law in North Carolina, which makes children adults from a criminal point of view when they turn 16 years old. We're one of, I think, the only or one of two states in the country that have that young age. So she's been very known as very compassionate in her courtroom and very compassionate out in public where she speaks frequently. Every day she's seeing these juveniles who have not had the kind of upbringing that would allow them to behave in a way that we hope that they will. And I think you'll enjoy her real life stories that she will bring at lunch. And the day will wrap up with some comments from local lawyer Keith Howard, who works for Advocates for Children's Services, another very passionate advocate for children who is daily representing them in a variety of kinds of forum that he'll talk about and his observations about the collateral consequences of juvenile adjudications. So just in conclusion, I think many of us might agree that a significant solution to ameliorating the harshness of collateral consequences is to just have fewer juvenile adjudications in the first place. Some evidence suggests that our communities are realizing that our sort of get tough approach is not really producing very good results. And while there is a long way to go, it seems that there are some policymakers who are beginning to accept the scientific evidence that we have that the adolescent brain just does not function like an adult brain. Study after study shows that cognitively, emotionally, and socially, children are not just small-sized adults. As a result of this, the social science is replete with evidence that meeting the needs of children to be safe, to be loved, to be cared for, to be talked to be educated, to be guided, and to have their illnesses treated will go a long way towards reducing the rate of juvenile adjudications. We seem still unwilling as a society to fully embrace that scientific evidence and incorporate its implications into our budgets and our policies. Instead, we just continue to pay at the other end on youth detention facilities and prisons that cost us vastly more than would early childhood programs. My hope is that we can all leave here today better educated, more committed to doing our part, whether as a scholar, a lawyer, a policymaker, or a community member, to improve the juvenile justice system in general and to reducing the impact of these collateral consequences on juvenile adjudications. Again, welcome to the conference and enjoy your day.